So we discussed the Supreme Court's ruling in the Trump immunity case a little bit earlier. We're going to discuss it again and again plumb the depths of the legal mind of one Professor Richard Epstein. But first, you know, the hue and cry from the left about this decision in which the Supreme Court essentially drew a line between the president's official acts and unofficial acts in terms of where immunity attaches. That would be with the official acts. And the official acts, though, within the confines of his Article 2 powers. It's such as willy-nilly, he so deems things official acts. So, in point of fact, no, he can't shoot someone on Fifth Avenue and get away with it. That's not an official act, though you wouldn't know that to listen to some of what you've heard, probably yesterday, including from Obama-era lawyers like his former Solicitor General, Neil Katyal. But it was also telegraphed, by the way, that this was where the Supreme Court was going to go. Because, and not that you can always divine things from oral arguments, but it's just so commonsensical. And the backdrop is really important, that the left put the Supreme Court in this position by engaging in lawfare. And the Supreme Court rightly is very concerned about mutually assured destruction under color of law for the purpose of politics. Alito made that point in oral arguments with the DOJ's lawyer, legal representation.
Let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So
yeah, but that's sort of unresponsive to the point that Alito was making in terms of facing a criminal prosecution and going back and forth. We win, we prosecute your guy. You win, you prosecute our guy, and we just go round and round. And where do you think that ends up? Neil Katyal, I mentioned on MSNBC, providing his color on the decision.
I have not. And what she's signaling here is it's not just about the Trump January 6th case. It's about every president who goes forward, indeed possibly Trump next year, and being immune now from the criminal law to be able to use the Justice Department in ways the court today calls absolutely immune to undermine elections, to go after individuals. This is according to the dissent, which it seems like as grave a shift in our constitutional system as any in our lifetimes.
Let me, Neil, she's arguing that he can assassinate somebody now. Is that what this majority opinion is saying?
Yes, that is basically what she's saying the majority is saying, and I'm sure that is how Trump will take it.
Mm-hmm. Right. Sotomayor, in her dissent, is arguing that Trump can willy-nilly, and this is platformed by an officer of the court, Neil Cattell, which is embarrassing, that he can willy-nilly assassinate people he doesn't like for no particular reason or any particular reason.
And
that's not the majority opinion.
Yeah, that's one of the themes they repeat throughout the campaign, that Trump is somehow going to be this vengeful monster when he's elected. But the big problem they're having is that Donald J. Trump was president of the United States for 4 years, and we survived it. We lived through it. I mean, all of these horror stories that they're telling, they have to look at the facts of what happened.
They also are quick to dismiss the other two branches of government as irrelevant.
Yes.
maybe that's a little bit of that's Freudian in some sense. I don't know. For more on this decision, its impact, we're pleased to be joined again by Professor Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law, Senior Lecturer at the University of Chicago. Professor Epstein, thanks for being with us again.
It's always a pleasure to go to Adventures with Dan.
Adventures with Dan, legal travails with Dan, something like that. So the reading of Sonia Mayorda's dissent, if you could comment on that and what Keital and MSNBC are saying about the prospect of Trump killing his political opponents.
Well, I mean, it's the prospect of Biden killing his political opponents. Let me begin by a kind of an interesting comparison. There was a recent case, Murphy against Missouri, in which it turned out many distinguished people, including my friend Jay Bhattacharya, were going after the Biden administration because what happened was they were essentially hounding everybody who disagreed with their positions by making promises and threats to the media platforms as to what went on. And then they go to court, and what does happen? Amy Coney Barrett, who's in the majority in this case, said none of these people have standing to do this. So what did they do? They essentially protected the Biden administration from some very, very serious stuff on the grounds that what's at stake here is only an individual complaint. What everybody knows what's at stake here is the institutional integrity of various branches of government. And so here you had systematic abuses of power by the Biden administration, which has gone completely unredressed. I have sued the Biden administration because it's an abusive practice in removing boards of visitors. And what happened is the Court of Appeals basically said you don't have standing to deal with any of this particular subject because the horribles that you feel had never happened. And so they talk out of both sides of their mouth on this particular situation. To make a third point about it, I guess it was at least once or twice during the course of the campaign, it turned out that Donald Trump said about Hillary Clinton, lock her up, lock her up, lock her up. And of course, we know the day he got into office, he prosecuted her for various crimes. No, what he did is, as he always does, he talks stupidly on the one hand, and then on his official role, he acts pretty much sensibly. If somehow or other they actually think that a president can go out and order the murder of the guy who's the chief majority leader of the other party, they have to remember that impeachment is still something for high crimes and misdemeanor, and it would be so fast that that sanction would actually hold. But to put it otherwise, if they're trying to talk about the kind of extreme cases, those are the cases that really prompt very strong political retribution, and the impeachment process would start to hold wholly apart from the question of whether it could be subject. Let me mention the fourth point. They did one thing which I thought was a mistake, which is they basically defended the result in Clinton v. Jones. And remember, that was a case of action that took place, which was purely private, long between president was in office. And they said, well, what could happen is you could start to take discovery. That was wrong. The correct way to deal with those cases is never to give the president any kind of immunity against the offense, but to say so long as you're serving as president of the United States, they can't take your deposition. What they can do is ask that the statute of limitations be extended so as to not be lost on the case, and that all documents be preserved, and that anything that you know you keep in the record, but you don't bring it. So I think, in effect, what they did is they gave too much to the opponents of the president rather than enough. And then as you look at the rather sad article that Larry Tribe wrote in the New York Times, he never mentions what the particular offenses are, but he says somehow or other we have the right to know about this. You may have a right to know about it, and there are thousands of ways to do it, But a trial in the District Court of Columbia, which is going to repeat of what happened with Alvin Bragg in New York, doesn't tell you anything about the president. It tells you everything about the political process.
So when Sotomayor says, and I'm quoting from her dissent, in every use of official power, the president is now a king above the law. How do you respond to that?
Well, I mean, if there's impeachment out there, it's crazy. If there are elections out there, it's crazy. If there are political repercussions out there in the short run, it's crazy. What happens is, whenever you're dealing with an immunity issue, you're dealing with two kinds of abuses, that of prosecuting too much and that of prosecuting too little. If you prosecute too little, there are a whole series of other sanctions that I just mentioned that call into play. But if you prosecute too much, there's nothing else that you can do to get out of this thing. You're like Trump in New York, where he's fought, but either in the case having to do with the money and in the case having to do with the so-called irregularity. Prosecution essentially dominates the scheme, whereas in non-prosecution, other things are there. So to give you but another example, we have tried for a very long time to ask the question of whether or not there can be prosecutions brought against public officials for malice if they act within the outer perimeter of their duty. That's a phrase that was used this time. It first came into great prominence in a case called Barr v. Mateo in 1959, in which it turned out that Justice Solomon said, no, we're not going to allow these suits too much trouble. There are disciplinary procedures that can be used, for example, by somebody who abuses his power, and there are political checks against him. Well, they got rid of that rule for a while. And what they discovered is every time you allow an action for malice, every case is a triable case. Because so long as you have political motivations lurking in the background, you have to take depositions to figure out what's going on. And one of the things that Roberts did that was correct, he said, this is not a motive inquiry. And sure enough, when they did this, they did it for a while, and then they had to restore the absolute immunity because the other system simply did not work. And so there's a kind of a history about how this works in lower cases, and the same rules and the same trade-offs that apply with minor official and smaller disputes are the very rules that apply when you're dealing with the president in these high-stakes games.
The other thing on this too that Roberts did in the majority opinion, and this needs to be included in the conversation. Yeah, the president's official act. The president just can declare what I did in this instance was an official act. A prosecutor can say, well, it wasn't an official act, but the burden is on him to demonstrate, to present the evidence that it's not an official act, and thus it has legal exposure. Well, that's how it should be.
Well, that is surely correct on this. I mean, there is another view of this, and I'm a little more hawkish even than the court on one thing. I think it often does happen that there is abusive stuff, but I think in some sense it's better off to initiate these actions, in the other political process after everything happens. I don't want anything to be brought against the president while he's in service. And this is my rough rule, is anything that the president gets that's protected while he's in service, you can't let him be sued for it afterwards because of all the chain of horrors that was mentioned by Justice Alito when he talked about the situation. Who is going to, if Biden does something stupid, which he has, he could be protected while in office, but do we want the question of whether he could assert the privilege to depend on what his successor in the office starts to think? And that was the thinking about this that took place a year ago. It's crazy. The immunity has to be used or waived by the party against whom the charges are brought, and not by a successor in office who may be his enemy or may be his friend. And so I think that this should be understood in light of the insurrection charges that the Supreme Court put aside. It is absolutely institutionally crazy to say that the Secretary of State of Maine can take a president off of the United States off the ballot where she thinks he's engaged in an insurrection. And you have to stop that, and you have to stop this. The key thing is anything that Trump did is fair game for political stuff. And in fact, my view is he's paid a very heavy price. If you had Nikki Haley running this election, she'd be ahead by 20 points. What's happened is the downdrift of what Trump did has made this into a close election where any other Republican would have walked away with everything. So there is a price that's being paid right now. The problem is the bigger price is being paid by Biden because, amongst other things, he does not want that tape to come out with her because it would show, and this is very important, it would show that he was non-compos mentis to a very serious degree, not just on the day of this debate, but 6 months or a year ago. And so this is a chronic deteriorating position. And the thought that somehow or other, if you have these two data points, what you can say is, he's just going to rehabilitate himself and like Phoenix coming up from the ashes, be a bold new president. That's not the case. He has degenerative conditions. It's only going to get worse. The reporters know all of this. The White House knows all of this. But just as they did this with the COVID people, they managed to suppress everything on the opposite side. Read the front page story on the New York Times, how it is that Biden managed to snuff out every bit of political opposition. And that fellow from Minnesota who ran against him, he's not even running for re-election. That's how powerful the Biden forces are. These guys are masters at revenge. And the idea that somehow or other he and his attorney general and his designee should determine the fate of a national election is really a threat to democracy. And I'm afraid that Justice Sotomayor has just lost all of her moorings on this particular stuff. She now sounds like a whining politician rather than a Supreme Court justice.
He is Professor Richard Epstein, the James Parker Hall Distinguished Service Professor, Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thank you as always. Appreciate it.
Okay, my pleasure. Take care.
Take care. He joined us on the Turnkey.pro answer line.
Connect with Dan and Amy on the AM 560 The Answer mobile app. Just text the word app to 64636 to download the app today.
One of the most important decisions you can make as a parent is where you send your kids to school. But these days, it's never been harder to know which school is best. Public schools have changed a lot, and you might be thinking about sending your child to a private Christian school. But you also know that private school can be expensive, and in this economy, you might think it's not an option. Well, think again. With halfpriceschools.com, you can purchase tuition vouchers for half the price of normal tuition for private schools. For nearly 10 years, halfpriceschools.com has helped families from all over Chicagoland make the dream of private school a reality. And that can be the reality for you and your child, too. Just go to halfpriceschools.com, search for a private Christian school near you, and purchase a voucher. It's that easy. Visit halfpriceschools.com. That's halfpriceschools.com.
I know we're getting several messages, people disagreeing with Professor Epstein about whether or not Nikki Haley would be up by 20 points. Yeah,